Welcome back to The Price of Business. I am your host, Kevin Price, talking to you about you and your business. We've got one of our regular contributors here on the program, Hessam Parzivand. He is a regular on the program. He is an attorney that specializes in employment law, and I'm always glad to have him on the program to talk about some stuff that's really important, that impacts businesses and impacts the individuals that work for businesses. Hessam, how are you, sir?
I'm doing well. How about yourself, Kevin?
Great, thank you. I think a great topic that's always coming up, always being looked at to be modified, is the Americans with Disability Act. Why don't you start off with giving us a little bit of history on that?
Okay, yeah, sure. The Americans with Disabilities Act was actually first passed in 1990 or 1991, but most importantly, as of late, it was amended in 2008 during the Bush administration, and there were some questions as to the interpretation of the act between 1991 and 2008. The amendment dramatically expanded what constitutes a disability under the Americans with Disabilities Act, and I would honestly, for employers, I would call it the Americans with Medical Conditions Act. And, so it covers it to the extent that, you have a medical condition of any sort that interferes with your employment and your employer is on notice of that medical condition, then, you're entitled to potential reasonable accommodations. So what is reasonable obviously varies dramatically based on the situation. For example, if you're a cashier at a company like Walmart, and let's say you don't have vacation time, but you need to go out for a surgery of some type, Walmart there's another law that has some coverage called the Family Medical Leave Act. But let's say you hadn't worked a year for Walmart, which is one of the requirements under the Family Medical Leave Act, then Walmart would probably have to accommodate you under the Americans with Disabilities Act and allow you to have leave and not fire you in that instance for taking too much time off.
Yeah, very, very interesting. So, by the way, did the Bush 2, did George W. Bush weaken George H.W. Bush's initial law, or just provide more clarification for it?
Well, I mean, the Americans with Disabilities Amendment Act of 2008 actually dramatically expanded the Americans with Disabilities Act, which was passed under H.W. So yeah, Bush 2 actually dramatically expanded the act at that time.
Yeah, very interesting. So, what do employers need to know?
Well, I mean, I think employers, the key thing that they need to know is that if their employee comes to them and says, "Hey, I have a medical condition and this is why I need to miss work," or I need to work shorter days because I have a medical condition, or if they ask for any type of accommodation of any sort, they need to take notice of that immediately, because for the unwary employer, let's say you fire somebody over the fact that you feel like they can't perform their job due to their medical condition, the ADA analysis comes into play, and you might get a call from a lawyer who says, I'm about to file a charge with the Equal Employment Opportunity Commission against your company because you violated the ADA. You didn't even consider this person for accommodation. Now, the other thing that is, I think, even more interesting, in addition, is that employers also need to watch out for mental health conditions in these particular situations. For example, just to give you a case example that I recently read, there was a court that had a clerk who had a anxiety disorder of some type, and for whatever reason, that anxiety disorder, she wasn't able to work with people all the time. But the court had tons of paperwork that it could have, it could employ that person doing, which wouldn't have involved, working with people who are coming up to the court clerk and filing papers or whatever it may be. So she says to her employer, I don't want to work up front as much. That really aggravates my social anxiety disorder. I want to do the paperwork in the back. The court had a policy that only more senior employees get to do the paperwork in the back, and you have to kind of work your way up. And not to say that she won or anything to that effect. At the time that I was reading this case, the judge had granted summary judgment, which means threw the case out before it went to a jury, and said no, this isn't going to work. And a court of appeal had overturned that summary judgment and said no, she does get to go to trial, and a jury gets to determine whether she actually could have been reasonably accommodated in this situation.
Mm-hmm. Mm-hmm. And the results?
The result is still unknown. I mean, that's all we know at this point is that case is going to trial.
Interesting. And and you're tactically dealing with these all the time. What does an employee need to keep in mind? Because it would seem to me that it's a little risky for him or her to take this kind of action against your employer if it doesn't prove to go well. It seems to me that they should really know. They should have really strong cause before they take this action.
Yeah. No. I mean, I think the key thing for employees to know is that they need to document when they tell their employer, instead of doing it orally, do it in writing, and they need to know their rights, that they can seek accommodations. And I mean, it's a reasonable accommodation. So it's kind of unknown. It's obviously nebulous under the law. And what is a reasonable accommodation obviously varies dramatically based on your position. I mean, if you're an operations manager for a company and you're the only operations manager, I would think that what is a reasonable accommodation in terms of leave that your company can provide you is much different from, a cashier at Walmart or something to that effect.
Yeah.
So depending on how many people in your particular role they have. But I think employees do need to know that, they do have these rights, and a lot of times employees may shoot themselves in the foot by not wanting to reveal their medical conditions and feeling like their medical conditions are private and have no place in the workplace, and that's one way to not get your rights, because if the employer doesn't have notice of your medical condition, they surely cannot discriminate.
Yeah, I tell you, if I were in this situation, I would begin that documentation obviously very early, but I would be calling an attorney like yourself very, very early before I began even engaging a little bit in my concerns with the company, because of just, particularly the smaller the business, the more flimsy the protocols involved, don't you think?
Yeah. I mean, I think smaller businesses are the ones who get caught. And important to note, too, that the threshold under the Americans with Disabilities Act is 15 employees. So whereas the Family Medical Leave Act, which I would argue has more extensive potential protections, that's 50 employees within 75 miles.
All right. Hessam Parzivand, and he's a great attorney. We love having him on and to talk about this important information. I love what you bring to the program. And you can learn more about him at PARZ, that's PARZ, FIRM, firm.com, parzfirm.com. Thank you, sir.
Thank you, Kevin.
When we come back, much more for you. Do want to remind you, best content here shows up over there at usdailyreview.com, and this is The Price of Business.